This is Michael Popok, and it's time for a special Legal AF hot take of my interview with federal Judge Michael Luttig. Judge Luttig served on the Fourth Circuit Court of Appeals. He's a lion of the Federalist Society and a constitutional scholar and a patriot of the First Order. And he joined me on Legal AF to talk about what is going on from his perspective as a former appellate judge with Judge Aileen Cannon, a trial judge that's presiding over the Mar-a-Lago case, criminal case for obstruction and for Espionage Act violations against Donald Trump. And I asked him for his view, with his experience, as to whether Special Counsel Jack Smith should ask for the disqualification of Judge Cannon, and will and would the 11th Circuit act on that and remove Judge Cannon from the case, replacing her with somebody else to continue the case and get that case tried. And I think you'll find intriguing his response and his analysis. Take a listen to the clip. Let me transition for a minute, as I think it's going to be a good point to do it, to pivot here. Now that you saw the lineup for the majority, the per curiam, the way the oral argument went, and the things that they've lit on to reverse engineer to get the result that they wanted here in this opinion, what do you think that means, if anything, for the April 25th oral argument and the ultimate decision by the United States Supreme Court on the narrow issue? I mean, I've done my own kind of hot take analysis on this. I was encouraged by the narrowness of the appeal that they're interested in. And just to frame it here for our audience, the only issue they care about on appeal, nothing to do with due process, nothing to do with whether he needed to be impeached and convicted, nothing to do with First Amendment, none of the other arguments that were raised ad nauseum at the DC Court of Appeals level. You've got this 50-page, well-reasoned, what I call airtight and waterproof decision by Judge Pan Henderson and Childs. And you've got a Supreme Court that needs to weigh in once again, hopefully for the last time in a while, into whether there's immunity for criminal conduct by a person sitting in the Oval Office. The only question that they want to hear about is whether a former president can use immunity about official acts while he was in office. And that wasn't, as we all know, that those words were chosen with care. And for me, I thought that was encouraging, because if those are the only 2 points that out of the entire decision rendered by the DC Court of Appeals that they want to, loose ends that they want to tie up, I think that means he's going to lose, because they either find that a former president can't use it, much the way that, Judge Pryor in the 11th Circuit found that a former federal officer can't use the removal statute, which we never heard in 270 years before in a decision. And they're going to make that distinction that Judge Henderson was so concerned about in the oral argument between ministerial and official and unofficial, and say, yeah, we're going to announce it. If you're a former president, you can't use it, and or if you were a president doing official acts, you can't be indicted for them. But for things outside the outer boundaries of that, you can be. What did you make of how the narrowness of the appeal? Call me crazy, what I thought about it, and what you think now, we've got a test run, a dress rehearsal here with the Anderson ballot case, an insurrection case.
I happened to be on the set at MSNBC speaking to Nicole Wallace when the news came that the Supreme Court had taken the case. And I think I probably said to her, because I had said it before that interview, there was not a reason in this world for the Supreme Court to take this case. Then while I was on the set, someone slipped the court's order in front of me, and there began all of the to and froing by the talking heads as to the meaning of the order, including the question presented. I believe that all of that discussion was a tempest in a teapot. Okay. Now, turning to the only thing that matters in that order, namely the question presented. Uh, as your listeners know, the Supreme Court always frames the issue to be decided, and it frames it narrowly or more generally, depending upon what it wants to decide in the case. I'm not encouraged or discouraged at all by the framing of this particular question. This is the question that needs to be decided, and nothing else needs to be decided. Now that's separate and apart from my discouragement, if you will, that the court felt the need to take it. In an ordinary circumstance, meaning 99.9% of the times, similar to these, the court, one, wouldn't take the case, but if it did, it would affirm. In this instance, the fact that the court took it raises concerns in my mind as to whether it will eventually affirm the DC Circuit opinion.
So you're worried now, and I don't know if what happened with Anderson makes you more comfortable or less comfortable, but that having now taken it, rather than just leave well enough alone with the DC Court of Appeals ruling and just say we're not taking this appeal, that seems to be right to us. The fact that they're going to take it could indicate that we're going to get some aspect of an immunity decision that could benefit Donald Trump.
That's what I'm saying. But yeah. But as I say that, we've not talked about literally the most significant point about the court taking the case, namely that that it is unlikely, as a result, that the former presidents will be tried before the election. I said, I think that night on CNN, that it's highly unlikely that the court will decide this case before the final week of session in late June, early July. And if you think about it, April 25th, that's only 2 months before July. And, well, in fact, and it took them 2 months to decide the 14th Amendment case, right? And, yeah. But in any event, once the court has taken this kind of case, it's really incumbent upon it to produce an opinion for the nation that's worthy of the nation. Yeah. It did not do that in Anderson against Trump. It simply must do that in this case, lest it's suffer, its reputation suffer legitimately in the eyes of the American people. But on the timing, so regardless, but let's assume July 1st. Well, Judge Chutkan has said earlier that Donald Trump needs 88 days. So let's call that 3 months. So that means the trial at its earliest would be held beginning the first week in October, 4 weeks before the election. And the trial is expected to take 2 to 3 months. So it's not going to be completed until after the election, if it's even started before the election. Most notably, if the trial could start the first week in October, that presents a very, very difficult question for Jack Smith. We can take judicial notice of the fact that Jack Smith doesn't want to begin the trial of the former president on October 1st, 4 weeks before the presidential election of 2024. But of course, if he doesn't, and if Donald Trump is elected president a month later, then he will never be prosecuted.
Yeah, and let me agree with you on all of that, especially at the rate that they generated this 10-page per curiam decision, which I hear you is not did not cover themselves with any glory in how with the American people, and they'll have to do better with the next decision, and it will take them inevitably longer. And then you're right, we're out of time there. The one thing that I want our audience to know about is how much you've worked behind the scenes, not just on various news shows and law and politics shows like ours, but working tirelessly behind the scenes, preparing and participating in filing amicus briefs, friends of the court briefs that have gone to the D.C. Court of Appeals and up to the United States Supreme Court. The two most powerful amicus briefs, one was written by your group of 7 former Republican administration senior leaders, judges, lawyers, and the like, including my law partner, Nick Rostow, who joined you on that one. And then the group that was written, the amicus brief that was written by the group of the 25 most highly regarded Civil War historians, especially in the area of law and civil and the rest, and our Reconstruction period, the laws related to Reconstruction, led by the Princeton scholar whose name just escaped me. But those were the briefs that really should have been used. Now, look, there's more work for you to be done, more work for you to do, not to give you homework. We got a judge down in Florida in the Mar-a-Lago case, Judge Aileen Cannon, that seems to like amicus briefs. Now, the two that she's got in front of her, one arguing that Jack Smith, that's what they call him, not special counsel Jack Smith. Jack Smith has no power. He was illegally appointed. He's unconstitutionally operating as a prosecutor whose budget was not properly approved through the appointment clause, and Biden didn't appoint him, the Department of Justice did. And she thought that was very interesting. It would be helpful to her in her decision making. She granted the amicus on her paperless order. And she also took another amicus from Stephen Miller, who used to be in the Trump administration, who's about as right MAGA as you possibly can think of, attacking the National Archive. And so I looked at the docket. There aren't any more amicus briefs. Somebody has to help guide her and take in these amicus briefs. And, the Biden administration has decided, I guess because he's also candidate Biden, running for re-election, and his opponent is the one that has all these issues. Like, they stayed on the sidelines during the Anderson case. The Solicitor General, the 10th Justice, did not take a position, did not file a brief. I'm hoping she'll do something. And they unleash her for the immunity case, because it troubles me that Joe Biden feels, and the Solicitor General feels, the optics of it look bad. We don't want to take a position when they play an important role in Supreme Court decision-making. And I don't think we should be abdicating that. But on the Mar-a-Lago thing, I sort of leave it on this. We got a judge there, brand new, in a relatively rural division of the Southern District of Florida. I practice in Florida. Judge Aileen Cannon, she'd only been on the bench for a year. Most of that was COVID time, and she'd had very few trials. Of course, nothing to do with Espionage Act, SEPA, or obstruction of justice against a former president. Nobody's prepared for that, but she certainly is not. She got reversed twice by the 11th Circuit Court of Appeals prior to the indictment, when she tried to interfere with the prosecution and investigation of Donald Trump and the execution of the search warrant, and was pretty handily admonished by the 11th Circuit. And now looks like she's about to make a decision, looks like to be the wrong one, about the release of the names of witnesses, including grand jury protected witnesses, secret protected witnesses, on the public docket, and on a motion for reconsideration indicated that she's inclined to make the Jack Smiths of the world reveal these witnesses. They're going to take her up on an appeal, citing clear error and manifest injustice. And now it's back in front of the 11th Circuit again. Another recall for a sitting trial judge on the same case. Do you think that Jack Smith should ask for her removal? And do you think the 11th Circuit would grant it and replace her on the case?
Michael, I'm just hearing the details of this. I've not followed that case at all, frankly. I didn't know until just now even what the issue is, though I'm familiar with the past instances involving her her trial of this matter. It's exceedingly difficult to remove a trial judge from a case. Exceedingly difficult. It is only done for the most egregious and in deliberate, quote, judicial misconduct. I put that in quotes because judicial decisions can be so egregious and so numerous that it could justify removing the judge from the case. I can't say at this point whether there's been a sufficient pattern of egregious judicial misconduct to warrant a removal of the case. I doubt it. But I will address, your question about Jack Smith. And he doesn't need my advice. He knows this, especially after having asked the Supreme Court to expedite the immunity case. That it would be a momentous decision by him to ask that she be removed from the case. I'm not in a position to say whether that would be justified. I'm just saying to your audience that it would be one of the most important prosecutorial decisions in this case or in any other like case to ask that the trial judge be removed. It would have to be beyond compelling in order for the judge to be removed from this case at this point. Let me go back because you before you turn to this case, you were talking about the fact that the Solicitor General of the United States did not express her views to the Supreme Court on the 14th Amendment case. I actually said publicly that I believe that the Supreme Court itself had an affirmative obligation to ask for the views of the United States. And I said the Solicitor General has an affirmative obligation to provide the views of the United States on those issues, whether or not asked by the Supreme Court. I believe that it was, an abdication of responsibility by the Solicitor General. I'm not going to comment on the Supreme Court, for the Solicitor General not to provide the views of the United States. Now, obviously, she works for the President of the United States, and it's likely that the question was raised and discussed at the White House. That would not have been inappropriate, and so it may be that she was asked not to participate. That's of no moment to me. I believe that the United States of America, through the Solicitor General, had an affirmative obligation to provide the views of the United States in the disqualification case.
Totally agree with you on that one. I don't think we can make that mistake again. I think it would be a mistake for the U.S. to be silenced. The United States Supreme Court likes to hear from the 10th Justice. They have a role to play, and they have a position that needs to be taken on behalf of the people, and I hope that doesn't happen again. Well, there's an example of what we do on a show we call Legal AF, a podcast on the MeidasTouch network on Wednesdays and Saturdays at 8 p.m. Eastern Time, only on their YouTube channel, and then on audio podcast platforms of your choice. We try to bring in newsmakers and people that make a difference at the intersection of law, politics, and justice all across the political spectrum. And Judge Michael Luttig is just one example. But if you like that kind of hard-hitting analysis and interview where we're not blowing smoke or sunshine, you've come to the right place. Don't change that dial. And until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.